Yes, we can.
Thank you. Good evening, ladies and gentlemen. A warm welcome to the first virtual masterclass on decoding capital maintenance law. Our host, Mr. Anand Shrivas, is a faculty at Vinayaka Missions Law School, Chennai, who's had an illustrious career spanning across several NLUs and leading private law schools of the country. Beyond academia, he's also been a part of notable law firms, the Planning Commission, and a management consulting firm. He specializes in corporate and financial law, and to further his interests in the field, he's launched this unique initiative of Nail a Niche Masterclass series on financial law. He's a proud alumnus of Hidyatullah National Law University and RTM University in Nagpur. He's also earned several certifications from University of Cattolica, University of Nanterre, Paris, and Japan Patent Office. Over to you, Anand, to kickstart the masterclass.
Thank you so much, Sheetal. Thank you everyone for joining in. As you know that today's class or session is on capital maintenance law, very less talked about in today's corporate sector, or very less talked about in the legal sphere, and very less researched in India when it comes to scholarly articles or scholarly work that you see is pretty less when it comes to capital maintenance law. And that is the reason why I chose this topic as the first topic for corporate finance nail a niche series on corporate finance law. Now, today's journey is more not to understand what is the law, or what are the rights of the shareholders, or what are the rights of the creditors for that matter, and what is the capital maintenance law. It is more more directed towards why the law the way it is, why the capital maintenance law is the way it is. That is something that we need to understand. And this is much more relevant to the final year students and the fourth year law students and 3-year LLB students, the third year students of the 3-year LLB program, and also the management students that are in their final year or also in their first years of their MBA studies, especially the students that are specializing in finance. So today's class or session is more about a story. So let me just share the screen. Yeah. So if you can see, what is the today's story? We have all celebrated this legendary cartoon of Tom and Jerry, right? And if you sort of relate and draw an analogy between different stakeholders of the company, especially two notorious stakeholders that are available in today's corporate structure. One is the creditors, another is shareholders. They both, most of the times, are acting for the benefits of their own, less for the benefit of their company. So we are going to study mainly how both creditors and shareholders behave. Now, I'm not going to attach any characteristics or any nomenclature to Tom in terms of who Tom is and who Jerry is, because they keep on reversing their roles in terms of how they behave in companies. So let's understand what capital maintenance law is. Now, capital maintenance law basically is maintaining share capital of the company. In many ways, the paid up share capital of the company, for the reason being that you want to sort of protect the shareholders of the company. Now, when you look at regulating the share capital of the company, especially the tussle between the shareholders and creditors, there are two ways to look at it. One, how the capital is raised, and second one, how the capital is returned. These are the two ways through which we can understand the conflict or tussle between the creditors and shareholders of the company. Now, mainly this conflict is very much visible when a company goes insolvent, or it's very much visible when a company is in what we call as twilight period. Now, twilight period is a period when the company is neither alive nor dead. It's a period when the company, yeah.
Yeah, we are not able to see the slide that you are trying to project. It's still on the first slide.
Oh, is it?
Yes. We just realized, so we thought we'd flag it out to you.
Now?
No.
Not yet. Okay, just hold on.
Yeah.
Just hold on.
Sir, could you please reshare the slide again?
Yeah.
Let me do that. Now, is it visible?
Yeah, we can see your screen, but have you selected the second one?
Yeah.
Yes.
Now can you see?
Yes, now we
Okay.
can see Tom and Jerry. Yes.
Okay.
Okay.
Okay. Thank you. Okay. So, yeah. So this is mainly the main purpose of the capital maintenance law is to regulate the conflict between these creditors and shareholders who sometimes act notorious in their companies. Especially, there is always a sort of a dispute between creditors and shareholders of the company, especially when the company is either insolvent or the company is sleeping into insolvency, which means the company is either dead or the company is sleeping into death. Now, when I say sleeping into death, what do you mean by that is mainly companies sick, and company becomes sick basically because of variety of reasons. But the primary reason for companies becoming sick is the huge amount of debts that they accumulate because of the various reasons, maybe the losses or due to the increased competition, or say, for example, sort of decrease in brand value of the company. There can be plenty of reasons for a company to sort of get into losses and then get into huge amount of debts. Now, these debts, once they surpass the amount of capital that they have, especially when the equity to debt ratio goes beyond 1:2, that is when these companies become insolvent, or they become, sort of sick. Now, that is the time when shareholders can act notorious. When I say shareholders can act notorious, what do I mean by that is shareholders may try to divulge the assets of the company when the company is getting into, insolvency. Same like if you talk about a caretaker who is caretaking a person, more or less before the will is made or by that person, he will try to sort of use whatever ways in which possible to get the assets in his name, right? Of a senior citizen or a person who is about to die. Similarly, when we look at the companies, shareholders are the ones, when the company is about to die, they will try to make sure that they are deriving huge amount of value from the company when the company is sick. Now, there are multiple ways through which the shareholders sort of control the company, and multiple ways through which shareholders can sort of defraud the creditors. Now, please understand there are two primary rules of company law, corporate finance law. The one is that when the company is alive, the shareholder controls the company. And when the company is dead, the creditors control the company. However, when the company is into that twilight period where the company is neither dead or nor alive, that is the time when you have a problem. And that is the time when there is a tussle. Even though shareholders, even that time, control the company, but the company is actually towards the post facto supervision of creditors, which means that in case the company slips into insolvency where they are not able to pay their debts, the company, the creditors then supervise the company as opposed to the shareholders. So this is the two primary corporate finance law that you need to keep in mind in order to understand capital maintenance law. Now, where is the conflict arising? Now, there can be ways in which shareholder can act naughty, and there are ways in which creditors can act naughty. So let's understand how shareholders can act naughty, or they act in a way that can be harmful to the company, that can be harmful to the creditors, that can also be harmful to the employees as such. So if you look at one of that is asset diversion. Now, if you see most of the companies, they pay large dividends, right? There's a huge payment of dividends these days by the companies, especially the FMCG companies. If you look at the tech companies, most of the tech companies do not believe in paying dividends. When we talk about Alphabet, that is Google, or when we talk about Meta, that is when we are talking about Facebook, they do not believe in payment of dividends. But companies like, say, TCS, Procter and Gamble, or say, for example, Coca-Cola, or other FMCG companies, they generally believe in paying steady dividends. So dividend payments can be one way of abuse. Now, I'm not saying that dividend payments are illegal. Dividend payments are there, and they need to be there because it's a way of incentivizing shareholder to retain their positions in the company, or to buy more in the company. However, the problem arises when a company becomes a loss-making company. The company becomes a sick company, and that time you decide to pay dividends. And there have been a lot of criticisms of many companies who have sort of paid dividends when they were actually sick, when they were not doing well. One of the examples that you can think about is of Boeing. Boeing Airways is one of the very good example of a company which paid dividends even when they were in distress. Similarly, another way is share buybacks. Share buybacks, we all see share buybacks in India. It's considered very positive, and it's considered as a positive action by the company. And among all the good things that are there, say, for example, when you go for a share buyback, basically you would want to increase the earning per share of the company, you want to increase the value of the company and all of that. But among all these genuine reasons, there can be a hidden motive also when it comes to share buybacks, that is to actually plunder the creditors' wealth, because you know that the company might slip into insolvency, and that is a time when the shareholders would want to sort of plunder the capital of the company and run away. Second aspect is riskier projects and underinvestment. So now this is very, very important. Now, when you go for a loan to anyone, I mean, in fact, if you are as a person also, you go to a loan, the person to whom you go for a loan would ask you, where do you want to put this money? And most likely, if you give a good answer to that question, you will get a sanction of a loan. Now, banks or financial institutions also sort of decide when to give loan and how to give loan based upon what is the purpose for which the loan is given. Now, this purpose is risk assessed by the banks in order to find out whether it's a good or bad sort of a project. Now, if you change that project, or if you change the company's direction towards riskier projects, then there is a problem. And the last one where shareholders can abuse, there are plenty of ways through shareholders can abuse, but these are the ways through which capital maintenance of a company can affect. Now, the last one that I want to talk about is claim dilution. Now, it is very much possible that a shareholder, a promoter of the company on behalf of the company might take loans and might have assets secured, may have properties mortgaged, may have assets mortgaged, may have IPs mortgaged, whatever assets that the company might have, they might mortgage it. Now, there is a chance, a huge chance, that there can be, the promoter can take loans from maybe few more lenders or other lenders without taking permission from the lender unless it is contractually agreed. So that results into claim dilution. And this claim dilution again is a problem for a creditor. So we are talking about actions that the shareholders can take which can affect the rights, possible rights of the creditors. Similarly, creditors, they are not someone who are, they are not saints. They can also act notorious that can affect shareholders' wealth and shareholder rights. Now, one could be requiring the company to repay loans early. Now, acceleration of loan clauses that are generally arbitrarily imposed on the shareholders can be one of such example. Similarly, declining to pay dividends. Now, contractually, a shareholder promoter might agree because he's starting up the company or the company is a mid-tier company or a mid-cap company can say, and they can agree that, okay, we'll not pay dividends or we'll pay this much dividends and we'll not pay more than that. Now, this can have a problem because at the end of the day, the profits that are derived that have to be paid as dividends to the shareholders, if not through dividends, maybe through various ways. So providing for restrictions or comprehensive restrictions can be one way in which the creditors can abuse their positions. Similarly, now we need to understand this tussle. Shareholder would always want to put the money into projects which will give them more returns because at the end of the day, they are the ones who get the lion's share of profit, right? They are the ones who get the large bounty if the projects go well. So they would want to put the money into much more riskier projects than as compared to creditors, because then creditors are the ones who are who get paid interest. So they are not too much of concerned about whether and how much profits are being made. So also not to encourage companies where there is an accrual of benefit only for shareholders. So these are some of the examples which I found out could be another problem as compared to shareholders abuse. And today's lecture is more about shareholders abuse because we are talking about capital maintenance law. And the primary reason or standing for which the capital maintenance law is there is the reason that shareholders might abuse their position. So we are understanding that from that perspective. So these are the ways through which shareholders can abuse their positions, but we are not going to talk about all of them. We all know that related parties transactions can be also one way of plundering wealth of the company. So asset sales which are based on low market value, that can be also one way of plundering the wealth. Disproportionate payment to executives of the company, that can also be one way of plundering wealth. Invoice manipulations, sale invoices, or under invoicing of company. We talked about dividend distribution. We have talked about excess debt. Shell companies can also be one of the ways through which the funds can be diverted. And I need not tell you that there are plenty of examples through which diversion of funds have taken place in India through shell companies. There are plenty of other ways like selective payouts, off the book accounting, and depleting asset value. So now, where is the protection? Where is the law saying,
excuse me, sir.
okay, we give the benefit or we give the sort
Hello.
of protection?
Am I audible, sir?
Yeah. Yes.
Sir,
Yes.
due to some reason, your slide is not visible. We are at the second slide, Tom and Jerry slide.
Still?
Yes, sir.
Okay, now it's visible?
Yes, sir.
Okay, so we'll keep it like this only.
Yes, so whenever you change the slide, sir, please click, use a mouse click.
No, I am clipping. I'm changing the slide, but I don't see why it's not happening on the screen. Okay.
Now
Okay,
it's
no
visible.
issues. Anyway, I'm going to share the slides with the participants so they can actually have a look at the slide.
Yes,
after
good.
the class. Now, when we talk about possible abuse, there are ways in which creditors are protected, especially in common law system. Whether we talk about UK or India, creditors are more or less contractually protected. They are not too much protected by law unless the company is insolvent. If the company is alive, as I told you, the shareholders control the company. But if the company is dead, the creditors control the company. So therefore, since the control is with the when the company is insolvent, that is when there is too much of creditor protection that is provided. Okay, we'll discuss all of that. But let's talk about when the company is alive, what is the protection that we get? Number one are contractual restrictions and security. Obviously, nobody is going to give you a loan unless and until a fixed amount of security is provided. Or there can be contractual restrictions which will say that you're not going to pay huge dividends. Or say, for example, you're going to say that, okay, even if you pay the dividends, you are going to take my approval on whatever payment of dividends that you're going to give. Also, there can be contractual protections which would say that, see, if at all there are claim dilutions. Now, claim dilution, as I told you, is when there is a security on the security. There are plenty of lenders sitting, and they are sitting without each other's knowing or each other's consent. So that is the point of claim dilution. Next one is equity cushion. Now, in India, we do not have too much of equity cushion example, except of the fact that the law says that minimum, and this was the earlier law which used to say that minimum capital that is required in a public company is 5 lakh rupees, and in a private company is 1 lakh, which is not now the rule. So therefore, when we talk about equity cushion, we do not have too much of law, except the fact that you have to maintain certain reserves in the company. That is one. Number two, you have to maintain a securities premium account. Number two. And number three is where equity cushion comes in, is a situation where the law says that, boss, your overall exposure cannot be more than the or cannot be twice than the equity cushion that you have. So these are some of the examples that you see when we talk about equity cushions. Then comes financial statements and disclosures. Now, we all know that if somebody takes a loan, even from us, we do keep a close eye on the person, because we know that the person may not pay the loan. So there are chances that the person may not pay the loan, and therefore we keep a close eye. Similarly, when a companies take loans, banks and financial institutions, they keep a close eye on financial statements. Now, and these financial statements, since most of the companies are to which the banks and financial institutions give loans are public companies, these are public documents that are available. And in case of private companies, there are contractually provided that you have to provide for regular financial statements and disclosures, so as to know as to what is the cash flow of the company and what is the profit and loss account of the company, in order to understand whether the company be able to pay off the loan or not. Now, another way through which the creditor protection is done is through strict law on dividend payments and buyback and related party transactions. Now, let's talk about buyback. Buyback is one of the major ways through which the abuse can take place. Okay, most of the companies might go for a buyback because they would want to reward their promoters, they would want to reward their shareholders. Now, there are many methods through which buyback can be done. One could be on an open market, another could be done privately. And especially on private buybacks, there are chances of abuse taking place in terms of especially the valuing of shares of the company when the buyback will happen and overvaluing the shares of the company. And the last one that you see in terms of protection, apart from these are like major protections. There are minor protections also that you see under the company's law here and there, but these are the major ones. And the last one is director duties. Now, director's duties say that whatever loan is given, it should be given bona fidely and for the purpose and benefit of the company. Do not expressly provide for creditor protection, but in a way says that, boss, you cannot take the company for granted and you cannot divert the assets that you have. If you have any questions till now, I'll be very happy to answer because we do not have too much of time. I can take maximum 2 to 3 questions for today's session. Anyone who has a question would be happy to answer. I hope people are listening. I know it's Wednesday, it's almost half the week past. Most of you might be tired also, but I hope most of the people are listening. And any questions you have till now on any concept? No questions? Okay, let's go ahead. Now, let's talk about dividends. Can you see my slides on distribution of corporate assets? Guys, can you see my slide on distribution of corporate assets? Am I audible? Hello? Zeel, are you there? Okay, audible. What the WhatsApp response is that I'm audible. Okay. So if you look at distribution to shareholders, distribution of corporate assets can happen through majorly 2 ways: dividend payments and buyback, reduction and redemption of share capital. Does anyone know as to what is the difference between a buyback of shares of the company, reduction of share capital of the company, or redemption of shares? Anyone? No questions? Okay. So if there are no more questions, we'll go ahead and continue our discussion on. So now there are 2 ways. This is very, very interesting. Some companies do not pay dividends and some companies pay dividends. I was expecting you guys might be more active. I would have asked more questions, but my possible question would have been to you was this: that why do companies don't pay dividends, and why some companies prefer paying dividends? Now, if you look at, and this is and I was researching on this, and if it's very, very sector specific, most of the tech companies abroad, they do not prefer paying dividends, and especially tech companies abroad, even though established huge companies. In India, startups, especially like Zomato or Ola for that matter, these kind of companies which are little tech driven, they do not pay dividends in India. What is the reason of non-payment of dividends? This is something which is very, very interesting to know. Similarly, we'll come to that reason. Similarly, if you look at, these are some of the examples that I talked about. One is Ola, Paytm, Zomato, and Make My Trip. These are some of the companies in India that do not pay dividends. And on the other side, if you talk about fast-moving consumer goods, the FMCG goods, say for example, Coca-Cola. Coca-Cola is one of the FMCG goods that where you see especially global companies paying huge amount of dividends and regular dividends, right? On the other side, you see that Companies such as P&G, Nestle, Unilever, they also pay hefty amount of dividends and consistent dividends. Similarly, if you compare that with India, Infosys and TCS are the ones who you see paying dividends. Now, this is generally considered as a virtue, and non-payment of dividends are generally considered as not a good virtue. Is that true? That is something that we need to ponder upon, because paying of dividends, as I said, is one of the ways through which you can divert corporate assets from the company towards the shareholders. Okay. And if you look at these companies, say for example, Amazon, Google, Facebook, Tesla for that matter, they do not pay dividends to their shareholders. They consider not paying dividends. In fact, they will put the money into these companies, reinvest the money into the R&D of the company, because mainly tech companies require huge amount of R&D. Also, that the tech companies such as Amazon, Google, Alphabet for that matter, sorry, Alphabet is the Google only, Meta for that matter, that is Facebook, they do not pay dividends for other reasons also, apart from R&D. Okay, and that could be, say for example, strengthening the company's position financially. This could be one. Another is acquiring other tech companies, because tech market is very much competitive. And there are many companies which would require in order to survive, to acquire the other tech companies. So let's look at the reasons. So reasons for payment of dividends. Number one, encourage investments. It's a good signal to the people, that boss, to the investors, that the health of the company is well and good, and you can actually invest into the company and you can stay invested into the company. It also shows that we have long-term confidence in the company's performance, and therefore we believe in paying steady dividends. Similarly, and this is most important part that I feel, is retaining investors, because most of the investors would want to leave the company if the company is not paying dividends. Okay, so retaining and paying back the shareholders are the reasons for payment. Interestingly, non-dividend payment drives a different factor altogether. Non-dividend payment is mainly towards tax. Okay, this is a very, very important point, because dividend payments are burdensome when it comes to tax payments in India as compared to capital gains. So therefore, whether it's India or abroad, it's the same situation where tax becomes a burden, and therefore the companies would not want to pay their shareholders. Similarly, reinvest into the company in many ways, into R&D, or acquire the company, or to pay the debts of the company. So these are the reasons why certain companies may not want to pay debts. Now, what is the law? The law says that, boss, you cannot distribute dividends unless there is profits. Okay. However, there is an exception to that rule. You can pay the dividends if you are a loss-making company from the reserves that you have created, or from the paid-up share capital, right? So all of that is possible through securities premium account and through reserves. The payment can be made of the dividends. However, you cannot exhaust the reserves. There are limits into as much as reserves that you can exhaust, that is around 10% of the company's total reserves. And also, not touching upon undistributable reserves. So there are distributable reserves and undistributable reserves. Say, for example, capital redemption reserves of the company and debenture reserves of the company are the two reserves which are undistributed. Now, when you talk about dividend payments, as I told you, dividend payments can be one way through which companies can take the creditors for a ride, and that is where the law comes in. And the law says simply that, boss, as long as the directors recommend the dividends, shareholders approve it, we do not have a problem. And in India, when we have a controlling shareholders, mainly most of the companies are controlled by the controlling shareholders, and therefore directors of the company would recommend whatever shareholders and promoters are going to say. So this is a very weak kind of law on dividend payments. Now, this is a very good example that you see today. You see there are many companies which are into distress but are still paying dividends. Now, this has a huge impact on creditors, because if you are paying dividends, even if you are a loss-making company, it might happen that you might default on a debt, you go get into insolvency, right? And if you default on a debt and you get into insolvency, means that you are plundering creditors' wealth, because the companies might go into or get into insolvency. Now, there are many loopholes in the law when we talk about is that it does not provide for too much of party approval or too much of a creditors approval. It is mainly decided by the promoters, recommended by the directors. This is one problem with the law. Another law problem is allowing loss-making companies to make dividends. One of the reasons that is cited for loss-making companies to keep paying dividends is to telling the shareholders that, boss, even though we are going through a bad time, we are going to pay you your dividends. And it's not as such a bad thing, but it becomes a bad thing if you take creditors' perspective in mind. Now, if you want to pay the credit out of the capital of the company, then there is approval of the NCLT that is required. That is very much justified and should be there. However, this is the loophole in the law that I talked about, which mainly driven by the directors of the company and especially promoters of the company that are there. Now, this is all about dividend payments. If you have any question on dividend payments, I'll be happy to take up, because I'm going to get into now buybacks. Are any questions on dividend payments? Okay, it seems there are no more questions on dividend payments. So let's talk about so Hartej has a question. Isn't it the case that most promoter-held companies are more inclined to pay dividends? Absolutely. In fact, if you compare to, especially in India, that is the fact that if you see most of the companies that are promoter-held, they are the ones who are more inclined to pay dividends. However, having said that, that is not entirely true if you take into every scenarios together. Because say, for example, in Facebook or Tesla for that matter, or Google for that matter, these companies are also promoter-driven companies, but and their shareholding pattern is not too diversified. In fact, the boards are also too concentrated. So even they do not pay actually dividends. They are much more sophisticated ways of actually taking out wealth from the company than only looking at dividends. You can type in your question if you want. I mean, if at all you have any question, you can type in. I think the audio is disabled of the participants. You can type in your questions if at all there are questions. Okay. Hartej, I hope I have answered your question. I'm moving fast because I need to cover buyback now. Now, buyback of shares is again considered as a virtue. If you see so many buybacks happening right now or taking place, especially from companies which are again promoter-driven companies, and especially if you talk about Infosys or you talk about TCS or you talk about Reliance companies, most of these companies are doing Reliance Industries. They are doing buybacks. Now, buyback of shares are generally considered as a virtue, and it's considered good. But there have been a lot of studies by Harvard Business School and for that matter, there have been a lot of research that has been cited in Wall Street Journal, which says that buyback of shares can be bad. Now, the simple example that I'm going to give you is if say for example, you have taken money from people, you have borrowed money from creditors as a person also. You are not going to put this borrowed money on depreciating assets. In India, sadly, that's the fact that you put a lot of money into car loans and electronic loans where there are depreciating assets. But it is very considered wise if the money is being put into assets through which you are going to get some returns, right? So whether we talk about property, gold for that matter, or even education for that matter, right? So that is considered as a virtue. Now, buyback for that reason becomes bad because if you're going to take money from the creditors and you're going to buy the shares of the company, they can be problematic for the creditors because creditors are going to you are going to eat out on the equity cushion of the creditors, and that is something that is not acceptable by the creditor. Similarly, when buybacks are made, generally from the open market, especially from open market, because buyback can be made from, say, tender offer, through private offerings, or through stock exchanges. And stock exchanges also, there are two mechanisms. That is too detailed to be discussed. That is SEBI buyback regulations. However, if you are purchasing from open market, generally you do not contribute the money that you took from the borrowers into productive capability of the firm. Also, buybacks can be manipulated and timed, and it is very, very important. Now, say for example, if I am a promoter and I want to sort of exit the company, or say I want to earn more out of a buyback because I'm going to increase the value of the company by doing a buyback. So if the company price is 300 rupees, I'll say that, okay, I'll do a buyback at 500 rupees, right? So I am actually paying 200 more, getting 200 more from the company. So the buyback can be timed in the stock market by the promoters. That is a problem. And also buyback, if there is a huge amount of buyback, it is also possible that, say for example, I'm a promoter, I own, say, 1000 crores of the 1000 crores shares of the company, and there are people that are owning only, say, 10 lakh shares of the company or 1 lakh shares of the company. Even though there is an equitable distribution of the buyback offers that are being made to these people, or in the tender offers that have been made, or tender of the shares that have buyback of shares that have taken place, even though equitable distribution has been done in terms of how much proportion that they are holding, it will lead to obviously more shares being bought by the promoters, and that is one way of also looking at things. Another important reason I feel when the buyback can become bad is when you see that especially CEOs and CFOs of the companies, their performance is decided on earning per share ratio. So the moment you do a buyback, obviously the value of the company is going to go up. the stock market price going to go up, and the company is going to be valued more. That is one of the reasons why you do a buyback. However, the underlying motivation for the same would be that boss, as if you see mainly promoters and promoters appointed CEOs and CFOs, they would say, let's go for a buyback because our incentives or KPIs are basically based on KRAs, basically based on the earning per share ratio. So if I'm earning, if the earning per share ratio of the company is good, I'm going to get so much in terms of the bonus. I'm going to get so much in terms of the returns from the company, and therefore buybacks can be really bad. So where does the law come in, and how does the law protect? And it's if you look at company law, you will find this as very dry. You will see that it's why the law is saying that buyback needs to happen only with free reserves, only through securities premium account, or funds obtained through further issue of shares. And not more than that. Only these three things. The primary reason for this is again creditor protection and keeping good amount of cushion in the company. Because if you are going to use the free reserves, how much free reserves can be used? And therefore the law says that, boss, you can go for a buyback only when the article provides, the articles of association provides, when all the shareholders agree. Now, what is the article of association? As you know, it's a contract between the shareholders where they decide as to when to go for a buyback, when to go for a reduction of share capital, when to pay dividends. All of that is decided through articles of association. How the transfer and transmission of shares happens, all of that is there in one of the company's important documents. However, having said that, if you look at the law and the intention of the law here is, the intention of the law is to give cushion to the creditors and make sure that the overall buyback do not go beyond 25%. So, of the paid up share capital of the company. So, at all times, there can be a buyback only through special resolution. Now, some of you might know special resolution, some of you might not know the special resolution. Basically, if you pass a resolution which is more than 75% of the total paid up share capital of the company in terms of the value, then you can pass a special resolution. That is when you see, if you watch these shows like Shark Tank, it's whether you watch it in India or outside, you will see this tussle between the founder and the sharks that, okay, how much are you giving me in terms of equity? Are you giving me 10%, 20%, 25%? And there are always these set numbers. The numbers will always be like 5%, 10%, 25%, 51%, 76%. The reason why is this there? Because all of these percentages decides as to how much voting value you have. And it's an interesting discussion when you look at Shark Tank and see that they are debating about how much someone needs to buy. Because if you are buying, say, 74% of the company, you cannot pass a special resolution. Or say, if you look at from the other side, if you have 26% of the company, which means that you can block important decisions of the company at 25%. And therefore, these percentage values also become important. Now, the other law which says that, okay, you can go for a buyback, but the outstanding debt cannot move from 1:2 ratio in terms of equity. Okay, so these are some of the examples in terms of how the buyback is regulated. And mainly these are, if you look at from the perspective of the creditor. Now, we talked about this, that there are ways in which buyback can be taken into use or misuse. Now, I'm not saying that, see, buybacks are bad, totally bad, you should not do buybacks. That's not what I'm saying. I'm just saying that buyback can be misused, but there are good uses of the buyback also. There can be a genuine issue. Also, say for example, the market is valuing me at 100 rupees, but I know that my company's valuation is at 200. So I want to show the confidence to people that boss, my valuation is better than as what the market is saying, right? So there are ways in which buybacks can also be good for the company. Any questions by now you have in terms of buyback? Let me just see Q&A if there are any questions. Okay. So not many questions are there. Okay, now let's look at buyback. Which companies have taken their creditors for a ride? Wells Fargo. Now, Wells Fargo, there is a documentary on Netflix if you want to watch about Wells Fargo. If I'm not wrong, I think Dirty Money series have a very good documentary on Wells Fargo. Now, these Wells Fargo have been criticized lately by laying off workers or employees while they gave back their shareholders. So this is another tussle. Even though this is not a creditor shareholder tussle, but this is more of a, this is not a Tom and Jerry tussle, but could be a dog and Tom tussle, you can say, right? So this is more of an employee and shareholder tussle than a shareholder and a creditor tussle. Similarly, IBM have recently paid extensive buybacks and done extensive buybacks. So when the moment you do extensive buybacks, basically you're paying back your shareholders. Similarly, if you talk about TCS, Infosys, and Wipro, recently they have conducted buybacks. However, they do not have any situations like this. However, we cannot deny any underlying motivation, right? So we cannot say that, okay, everything is good or for only good, right? So could be underlying motivation also. GE is another example, and this is one amazing example of pharmaceutical companies. Some of the pharmaceutical companies have done buybacks while they raise drug prices, right? So what you are saying is, boss, I'm going to take money from you and I'm going to pay my shareholders. I'm going to price drugs expensive. I'm going to pay the shareholders. Again, this is a consumer shareholder sort of a tussle. And the last one is Apple. Now, Apple has paid huge amount of money to their shareholders in recent times through buybacks. So Apple's may not be paying dividends. Say before 2012, they were not paying dividends to their shareholders. They have recently started paying dividends because they have become a little established as compared to other companies. Say for example, TCS or Infosys in India, they are like companies that were started in the 80s or 90s. Now, if you as compared to such kind of companies, Apple have done like came to into picture when we talk about iPod, right? iPod was a time when Apple was had actually came into forefront, right? Since then, Apple has been doing pretty well. And in 2012, that is when their shareholders and directors decided, now we are going to get the dividends. However, having said that, before they have done a lot of buybacks through which they have paid their shareholders. Now, the last important point that I want to share with you is what is the law on buyback? Now, the law on buyback, again, is basically concerning, especially when it comes to creditors. One of the main thing that is required for a buyback is that, boss, you can go for a buyback only if there is a company which is solvent. And this is a very interesting discussion because not many people would know that in ROC you would have to file a solvency certificate if you're going for a buyback. Now, this solvency certificate has been provided by directors, which says that, see, in my right judgment, this company is not going to get into insolvency or slip into insolvency for next 1 year. And therefore, the company can go for a buyback, which is then looked at from the auditor's side of perspective. Auditors also look at the decision of the buyback and also the valuation of the buyback. And then shares are cancelled when it comes to once the company buys back, the shares are cancelled, right? These are some of the procedures that are there. Now, when it comes to buyback, so there is a primary principle of law that you all need to remember is that nobody can be the owner of a company, nor can the company be the owner of itself. This is very, very important in terms of itself means the share capital of the company. Neither the company is owner of its share capital because obviously the share capital has been distributed, nor the shareholders own the company, right? If you look at it in more theoretical manner or you look at it from more public companies manner, you will see that most of the shareholders do not own the company, they merely control it. Now, what the law says is that, boss, once the dividend payments, the buyback has been done, you actually pay back you cancel the shares, right? Why you cancel the shares? Because company cannot own its own shares. No company can own its own shares, except in England, in UK, you have a concept of a treasury share, where a company for a brief period can own its own shares. In India, as the moment there is the buyback within certain days, you have to cancel the shares depending upon what is the method of buyback. As I said, there are many methods of buyback. However, as far as today's class is concerned, we will not be able to discuss those methods, but that is one thing that we need to keep in mind. Another aspect is in terms of buyback is that no associate company or a subsidiary company can buy the shares of the company when there is a buyback. Sell the shares of the company and the company can buy the shares. Now, the primary reason for all of this is market manipulation, right? There is a chance that through which there can be market manipulation that can be done through associate and subsidiary companies. So this is the law that is there, and there is always this back and forth between the creditors and shareholders, and mainly we talk about statutory law. There is also contractual law that comes into picture when we talk about creditors. When the moment creditors comes in, it's more of a contract than the law that regulates the debt, right? That regulates the loan that has been given, as compared to, say, a dispute between two shareholders that is more or less regulated by the law. Obviously, there also you have share purchase agreement, share subscription agreement, shareholders agreement that regulate their relationship. Also, you have what we call as articles of association that controls or regulates their relationship. Having said that, this is the entire debate on the Tom and Jerry, that is the creditors and the shareholders. As I said, you cannot attach value to anyone or name to anyone as to who is Tom and who is Jerry, because most of the times you will see that both are acting differently in different circumstances. There are a number of occasions when creditors have taken the companies for granted, and they have taken companies into insolvencies when they were not needed. Similarly, there are many ways in which shareholders have taken, made profit-making companies loss-making by plundering the wealth within the company and not paying their creditors. So this is there. There is a lot of discussion that can take place on waterfall mechanism under the insolvency law, and especially as to how they are covered. But however, that we will not be able to cover today. Maybe some other day we will cover. Okay. This here is the last point that I want to make is that the importance, if you look at, is protecting the companies through twilight period. That is where we are actually lacking when it comes to dividend payments or when it comes to buybacks. This is the time when the company is more susceptible to frauds, when the creditors are more susceptible to frauds, and there needs to be much more protection during that time than anything else, because the law says post facto law is applicable. Now, post facto law is under the insolvency code. there are avoidance transactions. Okay, there are preferential transactions and there are fraudulent transactions. All these transactions can be done in the past during the time when the company is when the company is sick and actually getting into insolvency. Okay. Having said that, I end today's session here. If you have any questions, I can take maximum 2 questions if at all there are. In the question answer box, you can write. Yeah, Suyash has a point here. I think it's perfectly fine to fire workers and raise prices and do buybacks given the current managerial landscapes focusing on increasing shareholder wealth or everything else. This is Suyash. This is an important thing, and I am going to share a reading with you on this. There is a professor in Belgium University, and he's doing research on short-termism. And in today's time, we are only talking about creating shareholders wealth. If you were to go into time machine and sit in the time machine and go 50 years ago, most of the promoters of the company would say that, see, our main motto is not to raise or increase shareholder wealth. Our main motto is to deliver value. We want to deliver value to all our stakeholders. So this has changed. This is something that has changed. But I do not agree with you on this point that, okay, firing workers and raising prices and giving back, in terms of doing buybacks, especially looking at the scenarios of the creditors and the workers, because that is a very short-sighted, vision in terms of how the company is to be looked at, right? And that is where a lot of research is being done in Europe, not in India. I'm actually writing a small piece for short-termism. I'm going to share it with you whenever you're free. We can discuss. But that is the problem with most of the companies today's time, and I do not agree on that, because if there is a philosopher in jurisprudence, in law, in philosophy, we call Jeremy Bentham, and he says that happiness of majority people should rule majority of organizations and the nations. However, in many situations that becomes a problem, especially when we are talking about protecting individual rights. And this is a debate between community rights and individual rights. And in progressive and democratic setup, mainly the individual right should supersede the community rights, and that is something that is the modern jurisprudence on law. So that is my answer to you, Suyash. If you have any counter question, you can just type it in. Anybody else who has a question, please feel free. I'm assuming Suyash has no more questions and nobody else has a question. So then we'll wind up today's session. Please note that this masterclass will happen every Wednesday of every week, and the timings might change. However, the theme will remain the same. This is an niche masterclass on the corporate finance law. We are going to discuss mainly financial law when it comes to SEBI or RBI or IID or PFRDA. These are some of the laws that we are going to discuss and also debate upon. Not only the laws, we are also going to discuss the business strategies and things that are important for the businesses, also our business students, right? So this is the end of today's session. Thank you so much for joining in. Thank you for your patience for hearing me. Thank you.